Okay, so updates on the executive action. I'm pretty sure everybody has heard one way or another. The Department of President Obama last year came up with a program to make certain changes to favor certain temporary visas for people who were here without authorization. In some of those programs, or a couple of those programs, is the most commonly known as the DACA, or Deferred Action for Childhood Arrivals, and the DAPA, and I'll talk about that one later. In 2012, and we'll talk about what is currently in effect, the DACA program was implemented. Well, last year, the president tried to expand it and give more people more opportunities to obtain a temporary authorization to stay in the United States. The expanded DACA, the terms for that program included people still under the age of 16 that had resided continuously in the United States since January 1st, 2010, physically present in the United States as of November 20th, 2014, and or unlawful presence here as of that date, and that were currently in school or in a GAD, had graduated from high school, and not be convicted of certain crimes, felonies, or other significant misdemeanors. And we go back to what I explained to you before, the good moral character and those crimes that might disqualify people even for a temporary program like this. That program, the DACA, the expansion, is currently being litigated. There was a suit filed, and the DACA expanded was supposed to take effect in February 16, and before it happened, well, the court ruled that it had to be suspended. No applications could have been filed until the court rules whether or not this is constitutional or not, and for the time being, it's still being litigated, and we still don't have any resolution on that one. So that one is pending. Same with the program for the Deferred Action for Parental Accountability, or DAPA. And that was the one that was going to help the parents of U.S. citizen children or lawful permanent residents to obtain a temporary stay, deportation if that was the case, and get work authorization and be able to stay in the United States. This program also required people to be present in the United States or residing in the United States since January 1st, 2010, physically present as of November 20th, 2014, and was no lawful or unlawful status as of November 20th. And again, no crimes and major convictions of felonies, significant misdemeanors, other kind of those records, and they were supposed to benefit these parents, okay? So this program, as well as the extension for the DACA, is under litigation. So nothing is happening. This program was supposed to take effect in May of this year, so well, nothing could have been done. We do not know, again, what is going to happen. Every day we get updates on what the latest rule of the court was, but nothing in concrete, and it could go on for months, hopefully not years, but most certainly nothing in the near future that we anticipate is going to take effect. So what is currently in effect? Well, continues to be in effect the program, the DACA program that was implemented in 2012. Under this program, it's still in effect, which means people who meet these qualifications can still apply for DACA, the Deferred Action for Childhood Arrivals. And they must be under 31 years of age on June 15, 2012, which is the original program that was later that President tried to expand last year, that is under litigation. So under 31 as of June 15, 2012, came to the United States before 16 and this is important, it's not one day after I have clients that come and say, well, I came here the day I turned 16. No. I came the day after I turned 16. No, it's before age 16. Unfortunately for some people, but that's the rule. Have continuously resided in the United States since June 15, 2007. Continuously is be here. They talk about casual and short trips outside the United States. As many things with the Department of Immigration is kind of one of those things that is subject to interpretation, what is casual, what is brief, and so to me, the ideal is you've never left the United States since you came in, or if you did, most certainly you were presently here since June 15, 2007.
Yes, excuse me. I have a question. If a person was residing in the United States, but that person went to Mexico to visit her mother, and then came back, would that be considered leaving the country?
It could.
It could? Thank you.
There's many factors. We can talk more when we do a consultation, because there's other things that we may need to look into. But yes, leaving the United States is leaving the United States. For purposes of this program, then, is the exception, or what they look at into whether it was a brief, casual travel outside that might qualify. But I don't know. I think we need more information on that. Okay? So live or reside continuously in the United States since June 15, 2007, and physically present in the United States since June 15, 2012. I know all these dates sound confusing, but here's kind of the way I can put things in perspective. If you came in before age 16, then the first thing you need to look at, okay, I came before age 16, was that before June 15, 2007, okay? Or it was June 15, 2007. Then we say, yes, okay, perfect. So I meet the 16, before 16, I was here in June 15, 2007, and then was I here in the United States on June 15, 2012? And the answer is yes. You would probably qualify to apply for the DACA. Another requirement is you have to be in lawful immigration status had expired or came in without the documentation. So if you had, for example, you came as a student, you have your F visa on June 15, 2012, but your visa expired after June 16, 2012, then you do not qualify. You had to be out of a status as of June 15, 2012. The requirement of education, you must have a high school degree, or be in school to obtain the high school degree, or be in school to obtain a GED, or have a GED. And we have clients that they finished high school and they didn't complete the high school. And right now they do qualify for for this program because they came in when they were supposed to, they were under the age of 16, all those requirements, but they never completed high school. So what we've done with them is they went back to school and registered for a GED program. As soon as they could provide this documentation showing that they are in a GED program, enrolled to obtain the degree, then they can apply. They would qualify to get into this program. However, they have to stay in the GED program to obtain the degree. It's not that they're going to go back and be in a GED program only to apply and then drop out. They can. They have to stay complete, get the degree to be able to renew the DACA petition again. What happens when they qualify for DACA? They get authorization to stay in the United States. They're not going to be subject to deportation if they are apprehended or anything. They get employment authorization, so, and the DACA is only for good for 2 years. Under the program that the president wanted to implement to extend the DACA, the authorization was going to be for 3 years. So right now it's only 2 years. It has to be renewed. Still the person has to qualify. Okay, what means? Well, they already proved they were here when they were supposed to, all these things. But what that means is, if at the time they apply for the DACA, they were in school and they were about to graduate from high school, or they were trying to get the GED, then at that point they will probably have to show that they did graduate, that they had their GED, that they didn't commit any crimes that will disqualify. That always has to be met. And what the Department of Immigration requires is that people apply for these renewals, that they apply for these renewals at least 4 months before the expiration, not more than 5. So it's in between 4 and 5 months. So apply for the renewal. Basically, because the Department of Immigration takes about 90 days, sometimes longer, to process these petitions. And what they don't want is people to lapse that status, kind of a status, and therefore not have authorization to continue to work. The work authorization expires. Employers are supposed to terminate an employee that doesn't have work authorization. So people should anticipate and file the renewal applications on time to avoid all those inconveniences. If the application is filed before time, again, more than 5 years, it's going to be rejected. So you want to be within that time. Once you file, you get fingerprints and the notices, and then you get the authorization again. There is a program that we find very useful and very good for military personnel or veterans. This program is in effect since 2013. What does, it allows people who are immediate relatives of people in the military to obtain green cards. Parole in place, or PIP, allows these people a close family relationship, and we're going to say who they are, to get, even if they came here without authorization, without documentation, if they are here illegally, they will be able to obtain the green card here without the waiver, without having to leave, because of this program only for relatives of people who are in the military. Who are these people? Well, spouses, unmarried children, or parents of people of active duty members of the U.S. Armed Forces, current member of the Selected Reserve, of the Ready Reserve, or veterans of the U.S. Armed Forces. Again, no criminal convictions. This doesn't mean that anyone who is a relative of one of these, they will get a green card. No. It just means for these close relatives, there's a special program. However, they still need to meet the requirements to get a green card. No crimes, good moral character, all those requirements have to be met. Otherwise, no green card, even if they have the possibility of getting it here without the waiver and all those other things that other people would normally have to go through different relatives. There is another program that took effect this year in May. May 26 was the effective day. Spouses, Ms. Banmus spoke or explained to you about the temporary visas, one of them, the H-1B visas. Dependents, that is spouses and minor children, minor under the age of 21, children of people who come to the United States in H-1B visas, they come with an H-4 visa. So if I get an H-1B visa, I can bring my husband with me, and I can bring my children under 21 that are unmarried. And those people, they come with H-1B, with H-4s. H-4s, spouses. Now, as of May 26, 2015, they can obtain employment authorization document. Before they couldn't. They came with the spouse and just stay home and raise the children or go to school if they could, but they were not allowed to work. Well, now they are. They can apply for an employment authorization document only under a couple of circumstances. The H-1B spouse has to have an I-140 immigrant petition approved or has received an extension of the H-1B visa beyond the 6 years term that is allowed by law, because the green card application has been pending for at least 1 year. So for H-4 people to be able to obtain an employment authorization, one of these two conditions have to be met. Otherwise, they won't qualify for employment authorization. Parole program for entrepreneurs. And I was just talking to a friend of ours here today about this program. They had been talking about this program forever. We can't even remember how long. They are proposing and they want to implement this for people, and here's the definition, how they put it into the proposed rules, is founders of startup businesses that demonstrate substantial U.S. investor financing or can promise of innovation and job creation through the development of new technologies might qualify, okay? Basically, the investors, remember Ms. Bettman's mentioned, you can come and if you want to invest in the United States and you bring your money, you open your company, and if you show that you have a substantial investment, then you might get the green card because it is in the national interest because of the substantial investment. But if the investment is not substantial, but significant, and I know we're already asking what is substantial and what is significant, the Department of Immigration knows, and hopefully they will let us know before we start applying for this, because what is the difference? But if the investment is not substantial but significant, then they are not going to get a green card, but they might get a temporary status. There is the parole in place. What is parole? Well, you really don't need an employment visa, you don't need an investor visa, but we're going to let you be in the United States to continue to do your investment. And we'll let you work, and we'll let you stay, special status, without any other kind of visa. That's the parole or temporary status, as opposed to you are here a permanent resident. And then you can live and have all the rights and obligations of a permanent resident. There is attached to this program income requirement. Obviously, if they're going to be looking at if your investment is substantial or significant, they're going to be looking at what kind of money you have. What is your investment? Whether is this good for the United States? Does it grow the economy? How good it is? So that's going to be one of the main requirements, income. Usually in this type of visas, they also look for not only the investment you're going to make, but also where you get the money from, is it lawful, not lawful, and whether you can continue to live in case the investment fails. Then they want to see that you have enough resources to continue to have the life you had before you made the investment. Okay. Questions? Yes, sir.
Is the Pearl program available for entrepreneurs anywhere in the world? And do you know when the application process will be open? Because you said they're still ending.
It's a proposed rule.
Right.
So until they actually come up with the regulations, what is the program, how it is going to be applied, we will not know what is the application and how is this going to work.
You don't have an anticipated date? Will it be the next couple of months? Or
No.
right now?
All of these programs, like the DACA and DAPA that are in litigation, this entrepreneur proposal is there as part of the new immigration reform that the President Obama is trying to get in place. But quite frankly, right now, in terms of that, nothing is happening. Everybody's invested in next year's election, so we know that immigration is not something they're going to be touching anytime soon. But definitely, once they come up with something, then they'll let people. And usually how these things work is the president, if he's able to, or the Congress comes up with a rule that says, or a program that says, we're going to create this program for immigration purposes. And then they give immigration, the Department of Immigration, and then is when things get kind of complicated. Then the Department of Immigration has certain time to come up with the rules how this program is going to work, what forms we're going to use for how long. They are the ones who are going to tell us how it's going to be implemented. Yeah. So we will let you know if that happens. Any other questions? Good. Now, Ms. Badmes.